Hello, welcome to our Unit 1 review. We're continuing on with Unit 1, the Foundations of American Democracy. We're continuing on with topic 1.8 today, which is constitutional interpretations of federalism. Right, we kind of introduced federalism in the last video, talking about the sharing of power between national and state governments, right? There's some powers given to the national government, right? These exclusive powers. There's some powers that are given to the states through the 10th Amendment, reserved powers. Those would include like the power to issue licenses, right? The power to create schools, right? The power to regulate intra-state commerce within trade within the state, and any activity going on within the state. So all those are key reserve powers. Others, creating police force, schools, healthcare, like hospitals, fire stations, and other types of public safety. Those are all reserved powers of the states, right? So today we're talking about the constitutional interpretations of federalism. The learning objective today is that students will explain how the appropriate balance of power between national and state governments has been interpreted differently over time. Okay, so the essential knowledge, there's a couple of them here that you need to know. The first one is that the interpretation of the 10th and 14th Amendments, the Commerce Clause, the Necessary and Proper Clause, and other enumerated and implied powers is at the heart of the debate over the balance of power between the national and state governments. Right, so we're talking about the balance of power between national and state governments. Who has the power to create policy? Who has the power to regulate and control? Right. So the 10th Amendment is important because the 10th Amendment basically says that all powers not passed by Congress or found in the Constitution are reserved for the states. And we talked a little bit of this in the last video too, right? So if you take a broad interpretation of the 10th Amendment, basically any power not given by the framers to the national government is a power given to the states, right? Regulating marriages. The most recent one, probably the biggest topic lately, has been same-sex marriage, right? Who has the power to regulate that? States began banning or passing laws that allowed for the same-sex marriage, but then the national government steps in. So that kind of leads us to the 14th Amendment, right? The national government steps in and says, that these state laws that are banning same-sex marriage violate the Equal Protection Clause, right? And the Due Process Clause. So the 10th Amendment is the exclusive power, the reserved powers for the states, right? The 14th Amendment comes in and says a couple things. One, that states cannot take away people's rights, our fundamental rights, without due process, right? So states don't have the power to take away our rights without due process. And also, all people are equally protected under the law, right? And that's where those state laws that were banning same-sex marriage came into conflict with the 14th Amendment, right? A person's right to marry who they want is basically, their equal protection, that those laws discriminating against those people, right? And again, this is a civil rights part of civil rights amendment that is designed to prevent discrimination, right? So that we are all equally protected under the law. And the state laws that discriminated were a violation of the 14th Amendment. The Commerce Clause, right? We're going to look at the Commerce Clause, and basically one of the required Supreme Court cases is that we're going to bring up, but basically the Commerce Clause says that Congress has the power to regulate commerce between states, with foreign tribes, with native tribes, and foreign countries, right? So what is commerce? Commerce is anything, right? Anything that can be bought, sold, traded between states. So we're going to look at that today, and how the Commerce Clause, how kind of the federal government used the Commerce Clause to overstep its boundaries, and the Supreme Court kind of reels that power back in one of the Supreme Court cases we're going to talk about. The Necessary and Proper Clause, another clause we're going to talk about today too, right? Which basically says Congress has the power to pass any laws they deem necessary and proper to carrying out their other enumerated powers, right? So the power to create a national bank, not listed in the Constitution, right? But necessary and proper to carrying out other laws like taxation, coining money, borrowing money, things like that, other enumerated powers, right? And other enumerated and implied powers as at the heart of debate over the balance of power between the national and state governments, right? So these implied powers, powers that aren't specifically listed in the Constitution, but are kind of derived from the necessary and proper clause, right? Things that aren't specifically given to the Constitution, right? And we're going to look at a couple of those today. One is under the Commerce Clause, and one is under the necessary and proper clause, right? These implied powers that aren't given to the national government, aren't given to Congress, but are implied through either the Commerce Clause, which is very vague, or the necessary and proper clause, which gives great deal of power to Congress, right, to pass any law they deem necessary and proper. All right, so the second essential knowledge point is the balance of power between the national and state governments has changed over time based on the U.S. Supreme Court interpretations of such cases as McCulloch versus Maryland and United States versus Lopez, right? Two required Supreme Court cases that you have to know, okay? So first we're going to start with McCulloch versus Maryland, right? And the background of the case is that the National Bank of the United States was set to expire, right? So they were going to renew the National Bank of the United States. Congress was set to renew that. And basically, Maryland, the state of Maryland, has a tax that any non-Maryland bank chartered within the state was subject to a fine, a penalty, right, or would be forced to shut down, right? So this was an effort by the state of Maryland to keep Maryland banks in Maryland and to prevent out-of-state banks from coming into Maryland, right? So an effort to basically protect the banks in Maryland. Makes sense. But what happens is obviously the second charter of this national bank is chartered in Washington, D.C., which happens to be in Maryland, right? So this is a non-Maryland bank chartered in Maryland, okay? So the Maryland law says that basically the national bank, David McCulloch, who is the banker, the financial banker of the United States Bank, is basically forced to pay a tax to the state of Maryland because it's a non-Maryland bank chartered in Maryland. So this case is going to go to the Supreme Court. And basically what the Supreme Court has to decide is two things, right? Remember, there's two constitutional questions. One, does Congress have the power to create a national bank, right? That's a key question. Second question is, does Maryland have the power to tax the national bank, right? So two-part question. First, if the first answer is no, then the second question doesn't even matter, right? Because the bank won't exist. So basically what they're trying to do is to destroy the bank, right? They're trying to tax the bank and destroy the bank. So does Congress have the power to create a national bank? And the answer, in short, is yes. Why? Not listed in the Constitution, right? It doesn't say that Congress has the power to create banks, but the Supreme Court rules that it is one of those implied powers that is deemed necessary through the necessary and proper clause, right? So Congress has the power to create a national bank. Why? Because of other enumerated powers, the power to tax, the power to borrow money, the power to coin money. Those enumerated powers basically imply that Congress has the power to create a national bank. So does Congress have the power to create a national bank? Yes. Why? Because of the necessary and proper clause. Second question, does Maryland have the power to tax? Does Maryland have the power to tax the national bank? The answer to that is no, they do not. Why? Because basically the power to tax is the power to destroy. That's what the justices come up with, right? The power to tax is the power to destroy. And if you're going to tax a bank, then you're trying to destroy the bank. Well, you can't, you can't do that. Why? Because first of all, that's a state law, and this is a national government bank, right? So the key clause here is the supremacy clause, right? That the national bank is supreme to the state law, and therefore the state law is invalidated, and the bank will stay, the national bank will stay, and the Congress tax is ruled to be unconstitutional, right? Judicial review, and the state law is struck down. So in that case, it's going to strengthen the power of the national government. It's going to strengthen the power of Congress, these implied powers, and the power to create a national bank, right? The second Supreme Court case, U.S. versus Lopez, is a little bit different. So basically what happens is the United States passes the Gun-Free School Zone Act, right? And Alfonso Lopez brings a gun to school in Texas, right? I don't believe it's loaded, but come to find out that he has a gun on school property. So he is expelled. He is sentenced under the law, right, under the Gun-Free School Zone Act, passed by Congress. It's a national law regulating guns in schools. So the constitutional question here is really, does Congress have the power to pass the Gun-Free School Zone Act, right? Alfonso Smith, who's convicted of the law, says Congress doesn't have the power to pass this law. What gives them the power to regulate guns in schools, right? So the question is, does Congress have the power to create a Gun-Free School Zone Act? And so it goes to the Supreme Court, and the Supreme Court decides that no, Congress does not have the power to pass the Gun-Free School Zone Act. Why? Because regulating guns in schools is not an act of commerce, right? They basically say that guns are considered commerce, but regulating guns in schools is not commerce. And we have to be careful about what we say is commerce and what we say is not, right? If we say that, yeah, regulating guns in schools is commerce, then that's going to open the floodgates to a lot of other activities that necessarily don't deal with commerce. So this is one that kind of reins back the power of Congress, right? The first, McCulloch versus Maryland, expands the power of Congress. This one puts a limit on Congress's power. It says, regulating guns in schools is not a federal power. It's not a power given to Congress. It's not part of this Commerce Clause, right? In fact, this should be an issue of the states. The states should have the power to regulate guns in schools because that is a reserved power through the 10th Amendment that should be reserved for the states. So not that guns can't be regulated, but Congress doesn't have the constitutional power to do so. So it kind of reins in the powers of the Commerce Clause. Takes away a little bit of power from Congress and gives that power, a little bit of that power to the states, right? If states have regulated guns in schools, right, that's their power. That's their power under this concept of federalism. So talking about the 10th and the 14th Amendment, the Commerce Clause, Necessary and Proper Clause, enumerated implied powers, McCulloch versus Maryland, U.S. versus Lopez, all this fun under federalism. So hope you enjoyed it. Take care. Talk to you soon.